Maneva na sema PENDREAM TV. PENDREAM TV de osia dem yopo.
Gagging people from commenting on this term agenda.
Correct me. Has he not been arrested to account for his stewardship of a public entity? How does that have anything to do with the tenure of a president? I mean, clearly, everything is going well in Ghana. We don't have anything to talk about, honestly. We don't have conversation. Right. We don't have any scandals to talk about. We don't have, So we sit and think, what did we talk about?
Okay.
Let's plug non-existent issues from the sky. Come on.
All right. So I'm Pratt and Laura said we should move on, so we'll move on. The president has made a definitive pronouncement on this matter. I guess that they should rest it. He said he's not interested, so let's move on with our lives. But there's one other issue which we cannot move on with. We cannot move on with our lives, even though it's been passed in Parliament, because there are still issues. Civil society organizations and labor unions are very uncomfortable with the passage of this bill. It's called the Tribunals bill. It was passed on Thursday by a majority. Well, not the majority. It was passed by only the majority in Parliament because the minority walked out. Since then, there have been all kinds of issues. So I see there are legal constitutional issues, there are financing issues, and there are also whether the basis for even activating this tribunal matter. And I'm saying activating because it's already in the law. It's not like we're bringing it. It's not new. It's there. We're just activating it. Whether the basis for activating is even sufficient, based on the data. And you look at the types of cases that tribunal is going to be looking at, and whether those are the kinds of cases that have choked the courts to the point where we need to create some other layers for those institutional layers to deal with them, And then I also see some other issues of history. Okay, history and the fact that there are historical memories embedding which doesn't make it, some people feel comfortable with the name tribunal, despite the fact that there's a marked difference between what we have here and what pertained the 70s, 79 and so on. Now, the flag bearer of the New Patriotic Party has waded into this matter. The minorities have been holding a series of press conferences and so on, and they've been kicking against them. And I mean the MPP. The party's flag bearer just yesterday released a video where he was literally advising the president not to sign the bill because of too many issues. Yes, he accepts that our courts are choked, but he doesn't agree that the way to go in decongesting the way the decongesting the judicial system is by creating another layer. And there are so many issues. It can be used as a tool for pressing and political persecution and so on and so forth. Or it lends itself to that. I want us to watch this video by the flag bearer of the New Patriotic Party, and then I'll tell you how the Daily Guide is also reporting it. Let's watch this video.
Hello, fellow citizens. I speak to you on a matter that has the potential to reshape our justice delivery system, confidence in our judiciary, and the future of our democracy altogether. The attempt to reintroduce tribunals into Ghana's judicial system. Last week, Parliament passed the Tribunals Bill 2026. The mandatory one-day interval between the consideration stage and the third reading was waived so that the bill could be passed on the same day. The minority's objections were voted down. Organized labor objected loudly and publicly, but was ignored. The bill will soon be transmitted to the President for his assent. I have one respectful request of President Mahama. Mr. President, do not assent to this bill. Pause and let the nation ponder and deliberate on this very important matter. This is not a partisan request. The Trades Union Congress, the voice of millions of Ghanaian workers, has called for the bill to be withdrawn altogether, warning that in its current form, it could become a potent tool for weaponizing justice delivery. Those are the words of Ghanaian workers, not of any political party. Consider also the government's own process. The President established the Constitution Review Committee, and it reported last December. This committee recommended removing regional tribunals from the Constitution because the High Court has long carried their caseload. Yet, the report of the committee has not been published. Before the nation has even read it, Parliament has rushed through and legislated in the opposite direction. Mr. President, publish the report first. Above all, Mr. President, reflect on the historical antecedents of the public tribunal system. Under this bill, panels that include persons who are not lawyers may sit in judgment over criminal matters. Ghanaians remember tribunals, and we remember what was done in their name. Our courts are congested, yes, but the answer to congested courts is to strengthen the courts, more judges, more courtrooms, and digitized processes. It is not to build a second system of justice. Mr. President, your government commands one of the largest majorities in the history of the Fourth Republic. With such numbers, Parliament can pass almost any bill it wishes. Not everything that can be passed should be passed. The larger the majority, the greater the duty of restraint. History will not ask how many votes a law received. It will ask whether the law is just, equitable, and seeks to promote and protect the interests of Ghanaians. My call is therefore simple and constructive. Withhold your assent. Convene genuine national engagement. Invite the Ghana Bar Association and other lawyers groups, organized labor, civil society, and the political parties, including my own. We will come in good faith and consult the judiciary itself, the institution that must live with whatever Parliament creates. Justice belongs to no government and no party. It belongs to the Ghanaian people. And a law that reshapes the architecture of justice should rest on national consensus, not on head count. Mr. President, the pen is in your hand. Use it not to assent to this bill, but write an invitation to the nation through the Council of State in accordance with Articles 90 and 106 of the 1992 Constitution. May God bless our homeland Ghana and make our nation great and strong.
All right, you're watching Good Morning Ghana on Metro Television. God bless our homeland Ghana and make it great and strong. That's the concluding statement by Ghana's former Vice President, former flag bearer, and currently the flag bearer of the New Patriotic Party, Dr. Alhaji Mahmoud Bawumia, essentially asking the President to hold on, to wait, don't sign the tribunal bill because there are some germane, legitimate, valid concerns about the bill, and not just, he said it's not a partisan call. This is the people of Ghana asking the President to hold on with the assenting to the bill, the tribunals bill, because once he assents, it becomes an act, and an act becomes a law. Now, today's Daily Guide actually captures it, and as Kofi Edu says that the opposition New Patriotic Party flag bearer Dr. Mahmoud Bawumia has urged President John Dramani Mahama to withhold assent to the recently passed Tribunals Bill 2026, warning that the legislation risks creating a second justice system and undermining public confidence in the country's judiciary. Addressing the nation in the controversial bill yesterday, Dr. Mahmoud Bawumia described the proposed reintroduction of tribunals into the nation's judicial architecture as a matter with far-reaching implications for justice delivery, democracy, governance, and the country's constitutional order. He appealed directly to the President Mahama not to sign the bill when it is presented to him, but rather suspend the process and allow broader national consultations on the matter. Amma, do you think this is a legitimate call by the flag bearer and leader of the New Patriotic Party?
I'm excited by the developments. I like the fact that he's wading into, the national conversation. It's a positive thing. For me, that's the whole point of a democracy, that we continue to share ideas, and informed ideas. We continue to take, positions, based on principle, based on, if you like, expertise, based on some research, and also that, as a government side, we take it on board. It's important. That's how we strengthen our democracy. So personally, as I sit here, I think it's an exciting development. My only takeaway, from that video would have been for him to, how do I even say this? So for instance, I would have preferred an interview, so that his positions can be questioned, right? So it's not just him saying what he wants to say, and that's the end. I would have preferred because I have questions, and I'm guessing that if somebody had the opportunity to sit down with him and interrogate his ideas and his reservations, perhaps I would have had some clarity, from that exercise. Maybe in a better form way, done in this way. And that's not taking anything away from what he has. It's just to say that perhaps maybe going forward, an interview would have been better, so that the views are challenged, so maybe better explanations are given. Because what he did, like I'm saying, it's exciting, it's important.
What would you, before you go ahead, what would you have asked Dr. Mahmoud Bawumia, which he's not already answered in the tape, in the presentation that he's already given or made?
So for instance, the clause 4 arguments he makes.
Okay.
I think he overgeneralizes, and forgive me, I think he I don't want to sound like I'm being combative, but I think he plays the gallery a bit, by overstating public opinion, that I think he's in a better position, to have deeper understandings of, if that makes any sense. Because he knows the import of the clause 4, right? And it's simply to get technical expert input into judicial decisions. That's what it is. That's what clause 4 is about, right? Because if there are very technical issues to be handled, which is the whole point of this bill, right, is to handle specialized cases to do with galamsey, cases to laws to the state. These are very specialized, very technical fields, So if the import of the clause 4 is to get the technicians in there, so it's not just the judiciary looking at the facts presented to it, facts that might be compelling based on the person giving it. You don't have institutional knowledge, you don't have institutional, understanding, you don't understand the backstory, of this technicality. I mean, I find it prudent that we are opening the doors to the people who know to come in and help with the decision making. I would have thought that that's actually a plus, for the bill. Okay. So it's not just because, let's be real, lawyers know the law, they don't know tax, right? At least those that's not their field. Or judges know the law and know as much as they can, but they are not experts in some very technical fields. So I would have thought that it's a plus to get the experts in there. For me, I mean, think about it. Which organ of the state is opening up its doors to technical men to come in and help them? It's a positive thing. Okay. So I would have asked him questions about the clause 4 because he seems to suggest that the clause 4 is problematic. Right. So that's where I'm a bit, because that's the one thing that I thought was actually
so you'd have sought clarity on that?
I would have sought clarity on that.
If you were interviewing him?
Yes. Okay. I'll say, please expand on this and explain to me how this is bad.
That's fine.
And others. Okay. There are other things, but I'll leave it here.
Okay.
Listen, nobody can run away from the fact that as a country, we have historical baggage when it comes to tribunals. Certainly not me sitting here. Most definitely not me sitting here, right? So, yes, there is that baggage. From what, 1982? I think it was PNDC Law 24,
yeah.
and then I think 1984, and then became
it actually started from 1979.
Do you understand?
Yeah.
You know, and these tribunals, we remember, you know, well, for me, not clearly, because I was just a baby, I think, but I lived through, you know, and I'm being very emphatic on the lived through. I lived through some of the excesses of these tribunals. And so, yes, there's that historical baggage. But the constitution of this country, the 1992 constitution, sought to right the wrong, made provisions for regional tribunals within the constitution. We do have a lacuna, right? We have a judicial gap. There's a hole there of the constitution mandating tribunals, but not being explicit or being perhaps clear on exactly how these tribunals should exist, should operate, you know, the extent of its power, and things like that. When you go over the bill, not only is the bill sort of giving oxygen to something that's already in our constitution, it is expanding on it, right? It's taking the powers from the executive and giving it to the judiciary. Who has oversight responsibility? It will be the Judicial Council. And what powers are we talking about? Operational powers, you know, oversight powers. It goes all the way to scheduling. Even scheduling the cases is going to the Judicial Council, right? Who goes where? All of these things are going to be handled by the Judicial Council. Who becomes presiding judge, for instance? Who gets to be empaneled, you know, at the tribunal? Who is sent where? It's very detailed, you know. So, I mean, yes, we remember the days when it was used for revolutionary, expedited justice. Remember those days. We know that, you know. Actually, wait, let me give the example of Sierra Leone. We all remember the specialized courts of Sierra Leone and the work they did. And it's interesting for me that till today, we didn't just do away with those courts. We kept them, right? And we made them relevant to, or at least they made it relevant to their contemporary democracy. I think that what this bill perhaps seeks to do is to, again, give oxygen to a constitutional provision that answers a need today. We do have backlogs. We do. The high courts can't handle all the cases our present contemporary today's Ghanaian democratic, you know, governance structure needs. There's a backlog. There's a backlog, you know, in terms of clearing these cases, but there's also a deficit in terms of how the decisions are arrived at, right? So, I mean, any call that says, let's expand the conversation is an important call. Anybody that says, let's engage broadly is not saying something bad, you know, to that extent. But any move towards deepening democracy is crucial. So we balance, right? And if you ask me to tilt, I would tilt towards deepening democracy, even though broad consultation is also important. So it's an important balance. I want us to not be partisan with this conversation.
Right.
I want us to, for instance, take the bill and read it in its entirety. I want us to never forget our history. It's important that we never forget where we are coming from.
Okay.
But I also want us to not let that history burden our progress.
Okay.
Right? So yes, tribunals in the past were not ideal, right? There was some arbitrariness in the way they operated. It was centered, at the executive. The executive literally had control over these processes. What is this bill seeking to do? How is this bill seeking to correct those excesses? Let's be dispassionate about it. Let's look at what has been proposed. And if it is in our interest as a people, by all means, let's, take it up with
I guess that the matter really in issue has to do with whether we need these tribunals. And as your critics and Dr. Mahmoud Bawumia has also said that yes, he acknowledges, your critics will tell you, they acknowledge that there's a backlog. Our courts are congested with just too many cases. And you'd hear lots of people tell you how they have a matter in court for 2 years, 3 years, 5 years, 6 years. It can be very frustrating, even though I've said it time and again that when you are on the other side, when you are the one who is being prosecuted, you would wish that the thing even travels for 10 years, But if you are the one who wants somebody else to go to jail, then you're saying time, time is being wasted. But so unanimously and collectively, I think that there's a certain consensus that, look, the backlog of cases, the cases are taking too long, etc. But we also know that this congestion is also an infrastructure problem, isn't it? I mean, we don't have enough courts, and I'm talking infrastructure, and of course, closely related to that is also human resource, which is the human beings and also technology and so on. Now, Amma, people have asked that instead of creating another layer, why don't you rather create more courts? Because when you read the Tribunals bill, there's actually an intention. There are plans to build infrastructure everywhere. Do you understand? To house the 3-member. That's at the very least, because the Tribunals bill says at the very least it must be 3. So you have the chairman of the tribunal and then 2. The 2 will look at fact. The judge or the president, who is a lawyer, has a legal expertise will look at the law, strictly speaking, and then the 2 will look at the facts, because they will be experts, as you rightly said, they'll be expert in one area or the other. Now, some have asked that, look, is the antidote really is setting up a tribunal? Why don't you just expand the court, build more court, employ more people, and so that you don't have to all intents and purposes, remind people of our past anymore? How do you respond to your critics when they say that, yes, we agree with you, but that's not how to do it, as Dr. Mahmoud Bawumia himself has said. That's not how to go about it.
So just to reiterate that this will not be a creation.
Yeah.
This bill is not introducing a new phenomenon, right? It exists already in our constitution. It's just that for in excess of 2 decades, we have not operationalized, something that we have already legislated on. It's already in our constitution. Regional tribunals, they're already in our constitution. This bill is not
perhaps
the one that...
perhaps the use of creation, again, is in context. Yeah, you're absolutely right. It's in our constitution. Well, we're reactivating them because it's been dormant for a while. So why are we reactivating? Because the reactivation is going to come with its own cost, which is, like I said, we have to build.
But we do have to build. You said yourself.
Yes, we
earlier.
have to build them.
Yeah.
And also remember that, unlike in the conventional, normal courts, traditional courts, where you have just a judge, now we're going to have 3, at the very least, at least 3 people. It could be more. Now, remember that all these 3 are going to be paid. That's extra cost to all of us. So those are the questions people are asking, that looking at the court, they're looking at the cost, and looking at the fact that we now have to set up the infrastructure to be able to activate this tribunal system. Aren't we better off just expanding the courts rather than reactivating the tribunal
but
system?
That's precisely expanding the courts.
Okay.
What is happening. It's precisely that. It's precisely expanding the courts.
Right.
If we all agree that as a growing democracy in today's 2026 Ghana, we need more courts, we need more experienced adjudicators, then it's the cost of democracy. And we need to do it. You have been more eloquent about why we need, to expand the terrain. And so for me, that conversation is moot. I don't think anybody is in disagreement about the need to do that. I think the only conversation, the only argument, perhaps the strongest argument against this bill is this whole historical baggage conversation. That's it. Any other conversation for me is moot, because yes, we have the backlog. Yes, we have specialized needs that need urgent attention, like Galamsey.
Okay.
How are we dealing with Galamsey?
Right.
If we catch, and permit me to be, this morning, if we catch our Galamseyers, where do we take them to? And where we take them to, how sure are we that the people that are going to sit on these matters know all the facts, have the backstory, know, just what I'm saying? Okay. And all of us are screaming that Galamsey is an issue. It's a horror that needs to go away yesterday.
Okay.
Yesterday. So please, I understand. I get it. Nobody will better understand this than me sitting here about tribunals, right? In our country's history. But our constitution has sanitized the word, the spirit of tribunals. Okay. Now, can we take what our constitution is saying and operationalize it for our benefits? That's it.
Okay. Laura, what exactly is your fear? The tribunal that existed before is not the same as today. We've come very far. We have cleaned things up. We have revolutionized that regime. A lot has changed. And when you
I'm not PENDREAM TV. Now, so far so good. Say open online portal le Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.